Hello everyone, welcome back to the channel Legal Ease. Today we are going to talk about orders and judgments and how they are different from decrees. So in the last class we have discussed about the decrees, the types of decrees, what is the meaning of decree, how will you differentiate these different types of decrees. So I hope all of this is clear because I did not see any problems in the comment section. So I'm moving ahead with the next topic, that is the orders. So, CPC uses these terms differently, and the interpretation used for these terms are also different. Orders are defined under Section 2, subsection 14 of CPC. It says formal expression of any decision of a civil court which is not a decree. So, the order is defined through the term decree. Anything, any decision of a civil court which is not a decree is an order. So, first of all, whenever you see a decision, you will of a civil court, you will first find out if it is a decree or not. If it is a decree, then it means it is not an order, and if it is not an order, that means it is a decree. So to understand the meaning of order, you have to see whether if it is an adjudication, that is by adjudication in a suit related to matters in controversy, and it is determining the rights of the parties, that is substantive rights of the parties, and a conclusive determination. Then, along with the formal expression, then it will be a decree. So, if any one of them is not present, then it can become an order. Let's suppose the decision is not given in a suit. That is, if it is given in any application or in any petition, it will be a order and not a decree. Similarly, if the rights are not substantive but procedural rights, then again it will be not a decree and an order. If the determination is not conclusive or conclusively not determining the rights of the parties, then again it will not be a decree but an order. And if the matter is not in controversy and the court has just made a statement regarding something that is outside the controversial matter, then again it will be an order. For example, if there is a suit related to right to property over a particular uh, property or building. Now, here the person who is a plaintiff has filed an application saying that I am an indigent person and I should be allowed to file as an indigent person. This indigency is not a matter in controversy. If the court decides that the person is an indigent or is not an indigent, the decision of the court will be an order and not a decree because it is not related to matter in controversy. Secondly, it is filed as an application. So even if the court is adjudicating in that matter, determining the right, whether it will be allowed or not, and conclusively determine that he should be allowed or not, then again it will not be a decree. Similarly, the power of the court to grant or reduce, uh, rejecting the granting of adjournment is also an order. The reason being it is a procedural right and not a substantive rights. So there are a lot of things that are considered as an order and not a decree because it is not fulfilling the requirements of a decree. Similarly, if there is a interlocutory decision, interlocutory decisions are basically the decisions that are given during the pendency of the suit so as to stop a party or ask a party to do something. Let's take an example from in a different slide. Let's suppose there is again a property which is in dispute between A and B. Now this particular house is in possession of B and A is asking for the ownership as well as the possession from B. Yeah, here B has started um, constructing something at the roof of this particular house. Now A is saying that if B keeps on continuing this particular construction, and if it is proved that it is my property and B does not have any right over the property, I will be forced to break it because I do not want to use it. I want to use the property as it is, and I do not want to make such changes in the property. So what will the court do? The court will temporarily grant an injunction wherein the court will ask B to stop the construction of this particular part of the property until the court decide whether the property belongs to A and B. If it belongs to A, the construction will not be done. If it belongs to B, the B will continue the construction later on. So that is again not a decree because it is not determining the right of the party conclusively. It is just giving a relief in between. Therefore, it is temporary in nature and it is also called as interlocutory. Okay, the injunction is one of the temporary injunction is one of the example that is given under CPC. So these are some of the examples which you can say are the examples of orders and not the decrees. If we go into the question of determining the difference between the two, they can be differentiated on the point, first of all, the meaning. So the decree consists of all the essentials that we have already seen under section 2, subsection 2, but order has only some essentials. First of all, it should be a decision of a civil court and should be formally expressed. Formally expressed matlab it should be expressed by the court. Formally means it should be written, signed, and all these requirements are needed to be fulfilled. So written plus signed is very necessary. So these are the two things to determine formal express. So any decision of civil court which is formally expressed and not a decree is an order. So it is given under section 2, subsection 14. So these are the two differences, the provision in which they are defined and the way they are defined. Third thing is, in a decree, the decision should be filed or decision should be given in respect of a suit only, while in an order, it can be related to an application, it can be related to either a suit or it can be related to any matter which is filed as a petition, anything that is not just a suit, including a suit but not restricted to suit is a or is can fall under the definition of the order. The third thing that can be a point of difference between the two is that the rights of the parties in decrees are substantive rights in for the purpose of decree. In order, again, it is not necessary that it is substantive. The rights are procedural as well. So any decision over the procedural right is also an order and not a decree. Similarly, if it is not restricted to procedure, any substantive right is there and the determination is not conclusive or other requirements are not fulfilled, then also it can be an order. So it can be anything. The next is that for a decree, it should be conclusive in nature, but an order needs not to be conclusive. For example, the recently we discussed the example of injunction. Injunction does not determine the conclusive rights of the parties, but it is determining the rights of the party for the time being or for temporary time. So therefore, that is a decree. That is not a decree, but an order. So conclusive determination is necessary for decree, but not for order. Next difference, which is very important difference, is related to the appealability. Now, appealability is one of the reason for which the question related to the difference between decree and order comes into picture. So decrees as a general rule are appealable, but orders as a general rule are not appealable. So decrees are appealed under section 96 as a general rule, but orders are not appealable. Exception to this is given under order 43 rule 1 of CPC, which says that these orders that are mentioned under this particular rule, only those orders are appealable orders, otherwise all the other orders are non-appealable. Similarly, decrees are appealed under 96, under section 96 itself, some exceptions given, so those decrees are not appealable, but generally they are appealable. So these are the different, we can say differences between decree and order. One more thing that can be considered as a difference is decree is divided into different types like preliminary decree, final decree, partly preliminary and partly final decree, deemed decrees, but orders are do not follow such distinction. Orders are always final, and there is no preliminary order, there is no partly preliminary, partly final, or deemed order. So this is it related to the distinction between a decree and an order. I hope it is clear. If you want detailed examples and the notes for the examples of decrees and the orders and anything related to it, please comment it or so that I will know, and then I will be able to provide you with the notes wherein I can give you the examples of what is a decree and what is an order. Coming to the next topic, that is judgment. Now we have understood the meaning of decree and the order. Now this judgment is also a term which is used by everyone. What does this term mean? So this is defined under section 2, subsection 9, and it means the statement given by the judge on the grounds of a decree or order. That means it includes decree or order, or it gives the reason behind the decree or an order, and it is the whole statement that is stated by the judge. Whenever you read any document from the court, it consists of everything along with the final decision that is executable. Executable matlab that you can go to the court to get executed. Usually, the executable part of a decision is called a decree or an order, but the remaining part, or including this part, is called as a judgment. So, a judgment shall consist of all these requirements. First of all, statement of fact, that means the facts of the case, so as to make the parties clear about what was the controversy between the parties, what was the contentions of both the parties. Then, point of determination, that is the issues between the parties on which the court has given its decision. Then the decision, what is this, can be a decree or an order, and then the reasons for the decision, wherein why this particular decree or order was passed, what were the evidences collected, what were the evidences rejected, plus whatever the arguments of both the parties given, and whether those arguments were accepted, rejected. All these things are mentioned under the judgment. So everything including these things is called as the judgment, while a part of it is the decree or an order. So when we talk about the judgment, it means everything is there, while decree and order does not in itself tell you about the controversy which is involved in that matter, does not tell you about the facts of the case. So they are not self-sufficient in itself. While if we say talk about the judgment, they are self-sufficient because if they talk about the case as a whole, where you do not need to see any other document to understand what the case says and why the court has reached to a particular decision in that particular case. This is one of the important case on the judgment, which says, decided by Justice Vivian Bose. He said, the judgment is a final decision of the court intimated to the parties and to the world at large by formal pronouncement or delivery in open court. This is one of the method which is also mentioned under Order 20 of CPC. Judgment can be formally pronounced or delivered in an open court. So it is the final decision and it is self sufficient in itself to understand the whole case because it contains everything, that is the facts, issues, decision, as well as the reasons behind it. So this is it for today. I hope you are able to understand everything. Again, in case of any doubt, you can always contact me. You can always comment on the comment box and I will be there to help you. So thank you and stay tuned for the next videos.